Mar-a-Lago, the exclusive Palm Beach club that has served America's political and business elite for over a century, just had federal marshals seize control of its operations this morning at exactly 6 a.m. Not because of another FBI raid, not because of criminal charges, not because of political persecution. U.S. Marshal Jennifer Rodriguez told reporters directly, asset seizure pursuant to civil judgment enforcement under Federal Rule 69. I'm Barbara Green, and this is the only official channel. Beware of imitators trying to capitalize on breaking news. Before we go any further, I need you to do something right now. Hit that subscribe button, click the notification bell for real-time updates on this developing story. Leave a comment below telling me, have you seen property seizures in your area? Yes or no? Share this video with everyone who needs to understand what's happening, because what I'm about to show you is playing out across luxury markets nationwide. Following the legal documents wherever they lead is what sets this investigation apart from mainstream coverage. This isn't partisan spin. This is evidence-driven reporting that respects your intelligence while making complex legal processes viscerally understandable. Here's the core argument tonight in plain language. This isn't about politics. This is about math and constitutional law. The $540 million judgment represents the largest civil enforcement action in American political history. Tonight, I'm going to walk you through the legal domino chain that led to this moment, the human impact stories mainstream media won't tell you, and the systemic consequences rippling through property markets right now. I'll show you exactly how we got here and who pays the ultimate cost. The 126-room estate sits on 17 acres of prime Palm Beach real estate. Built in 1924 by serial heiress Marjorie Merriweather Post, it became the Winter White House during previous administrations. This morning, that history became irrelevant. Federal marshals arrived with court orders, inventory warrants, and seizure protocols. The security team, bound by legal obligation, cooperated fully with federal officers. Club operations suspended immediately. Members received notification that all events, dining services, and accommodations would cease during the enforcement period. Staff members, many with decades of service to the property, gathered their personal belongings under marshal supervision. When federal marshals execute court orders, constitutional due process has concluded. The time for appeals, settlements, and negotiations has ended. What you're witnessing is the American legal system working exactly as designed, regardless of political status or personal wealth. This enforcement sets a precedent that extends far beyond a single property or individual. Property rights in America exist within constitutional boundaries. When civil judgments become final, enforcement becomes mandatory. No exemptions exist for political figures, business leaders, or celebrity status. The morning's events represent more than legal procedure. They signal a fundamental shift in how civil judgment enforcement operates in high-profile cases. Federal marshals don't distinguish between commercial properties and personal residences when executing court orders. Legal obligations supersede political considerations every single time. Think about that for a moment. A property that hosted presidents, foreign dignitaries, and Fortune 500 executives now operates under federal control. The same legal mechanisms that protect ordinary citizens' rights to collect judgments apply to the most exclusive addresses in America. Translation: the rule of law recognizes no special exemptions based on social status or political connections. But here's what they're not telling you about who gets hurt when enforcement actions cascade through luxury property markets. The human cost goes far beyond headlines and legal procedures. Tomorrow, I'll show you the 300 people whose livelihoods disappeared overnight, and the local businesses facing bankruptcy because of this single enforcement action. Because this story is not about politics, it is about people. Here's how we got to this morning's enforcement action. The legal domino chain that led federal marshals to Mar-a-Lago started 22 months ago in a Manhattan courtroom and followed constitutional due process every step of the way. February 16, 2024, Judge Arthur Engoron handed down his ruling in the New York civil fraud case. $355 million in penalties against the Trump Organization for systematically inflating property values on loan applications and financial statements. The judge found decades of deliberate overvaluation across multiple properties, including Mar-a-Lago itself. But here's where the math gets brutal. Civil judgments in New York accrue interest at 9% annually from the date of the ruling. That's $112,000 every single day the judgment remains unpaid. Not weekends off, not holidays, every day the meter runs. March 25th, 2024. The New York Court of Appeals reduced the required appeal bond from $464 million to $175 million. Trump Organization posted that bond through Night Insurance, buying time for the appeals process. Legal experts called it a temporary reprieve, not a permanent solution. August 21st, 2025. Here's where it gets complicated. The appeals court issued a mixed ruling. They upheld the underlying fraud liability findings, but reduced some penalty calculations. The core judgment survived. Property values were systematically inflated, civil fraud occurred, penalties must be paid. December 15th, 2025. Final settlement negotiations collapsed. The New York Attorney General's office had offered a structured payment plan that would have avoided enforcement action. The deal required acknowledgement of the fraud findings and agreement to independent monitoring of future property valuations. Those terms were rejected. January 8, 2026. The appeal bond expired. Under New York civil procedure law, when appeals are exhausted and bonds expire, enforcement mechanisms activate automatically. No additional court hearings, no further negotiations. The judgment becomes collectible through any legal means necessary. Let me break down the math for you, because this isn't abstract legal theory. This is compound interest mathematics in real time. The original $355 million penalty accumulated interest for 18 months at 9% annually. Add enforcement fees, collection costs, and additional penalties for non-compliance. The total reached $540 million, including all legal costs. Translation: when you owe money to a court system, the bill keeps growing until somebody pays it. Now watch the domino sequence that made this morning inevitable. First domino, property valuation discrepancies documented across decades of loan applications. Mar-a-Lago valued at $18 million for tax purposes, $739 million for loan collateral on the same financial statements. Second domino. Civil fraud liability findings survive initial appeals process. Multiple courts reviewed the evidence. The pattern of systematic overvaluation held up under appellate scrutiny. No constitutional violations found in the proceedings. Third domino. Settlement negotiations fail over admission requirements. The Attorney General's office needed acknowledgement of wrongdoing for any payment plan. Legal strategy prioritized denial over negotiated resolution. Fourth domino. Bond expiration triggers automatic enforcement procedures under state civil law. When appeal bonds lapse, sheriffs and federal marshals gain authority to seize assets equal to judgment value. No additional court approval required. Fifth domino. Federal marshals execute civil judgment under court order. This morning's action followed standard asset seizure protocols. Same procedures used for any unpaid civil judgment in federal jurisdiction. Sixth domino. Asset inventory and control transfer begins. Federal agents must catalogue everything of value to determine liquidation priorities. The process continues until judgment satisfaction or successful appeal bond posting. New York Attorney General Letitia James released this statement yesterday. Civil judgments must be enforced equally under law regardless of political status or personal wealth. The rule of law applies to everyone. Federal judicial expert Professor Sarah Chen of Georgetown Law told Reuters. This follows standard protocol for high-value civil enforcement. When appeals are exhausted and bonds expire, asset seizure becomes mandatory under federal procedure. Constitutional law scholar Dr. Michael Rodriguez explained to the Wall Street Journal, When appeals are exhausted, enforcement becomes mandatory. Courts cannot make exceptions based on political considerations or social status. Legal analyst Jennifer Walsh from New York University told CNN, "Property rights exist within legal framework boundaries. Civil judgment enforcement represents the system working exactly as designed. Here's what makes this enforcement action constitutionally bulletproof. Every stage followed proper due process. Original trial included full legal representation, jury proceedings, and judicial oversight. Appeals process provided multiple review opportunities. Settlement negotiations offered reasonable alternatives to enforcement. The federal marshals executing this morning's seizure operate under clear legal authority granted by civil judgment law. No political considerations enter the enforcement equation. Asset value determinations follow market-based appraisal standards, not political preferences. This isn't about one individual or one political party. This is how civil enforcement escalates through proper constitutional channels, when judgments remain unpaid. The same legal mechanisms that protect ordinary citizens' rights to collect civil damages apply to the highest-profile cases in America. But here's what nobody anticipated. When you seize control of a property like Mar-a-Lago, you don't just impact the legal parties involved. You shut down an entire economic ecosystem that employs hundreds of people and supports dozens of local businesses. And that's where this story becomes about real human beings trying to figure out how to pay their mortgages tomorrow morning. At exactly 6 a.m. this morning, 3 black SUVs pulled through the ornate gates of Mar-a-Lago. Federal marshals stepped out carrying leather portfolios containing court orders, inventory warrants, and asset seizure protocols. The security team, trained to handle everything from foreign dignitaries to paparazzi, had never encountered anything like this. Lead Marshal Jennifer Rodriguez approached the main security checkpoint and presented the legal paperwork. Court orders for immediate asset seizure pursuant to civil judgment enforcement. Inventory warrants authorizing complete cataloging of all property contents. Seizure protocols granting federal control over club operations pending judgment satisfaction. The security supervisor, a 20-year veteran of the property, read through the documents twice. Under legal obligation, he cooperated fully with federal officers. No resistance, no delays. Constitutional due process had concluded months ago. This was simply the enforcement stage of a legal judgment that had exhausted all appeals. Club operations suspended immediately. The concierge called every member with reservations for the next 30 days. Dining room service terminated. Golf course access restricted. Wedding receptions scheduled for this weekend were cancelled. Overnight guests in the club's luxury suites received notice to vacate by noon. Staff members, many with decades of service to the property, gathered their personal belongings under marshal supervision. Locker cleanouts, desk drawers emptied, personal photos removed from office walls. The same people who had served presidents and Fortune 500 executives now watched federal agents inventory everything they had spent their careers maintaining. When federal marshals execute court orders, constitutional due process has concluded. The time for legal arguments, settlement negotiations, and political appeals has ended. What you witnessed this morning is the American legal system operating exactly as designed, regardless of political status or personal wealth. Now let me show you exactly what the federal government just took control of. Mar-a-Lago sits on 17 acres of prime Palm Beach oceanfront property. 126 rooms, including 20 guest suites, a ballroom that seats 400 people, 3 bomb shelters built during the Cold War, and a private beach club with Mediterranean-style architecture. But here's where the numbers get interesting. The Palm Beach County property assessment values Mar-a-Lago at $18 million for tax purposes. That's the official government valuation used for property tax calculations. The Trump Organization claimed the same property was worth $739 million on loan application documents submitted to Deutsche Bank and other financial institutions. $739 million versus $18 million. That's not a minor accounting discrepancy. That's a 4,000% valuation difference for the same 17 acres on the same date, using the same property records. Think about that for a moment. The same property claimed to be worth nearly $750 million for borrowing money was assessed at $18 million for paying taxes. Federal marshals are now determining which valuation reflects actual market reality. Additional properties identified for potential enforcement action extend far beyond Florida. 40 Wall Street in Manhattan, a 63-story Art Deco skyscraper in the heart of the financial district. Commercial and residential floors in Trump Tower on Fifth Avenue. Seven Springs, a 213-acre estate in Westchester County with a Georgian mansion and private golf course. Golf course properties across multiple states remain under review for potential seizure. Trump National Golf Club in Bedminster, New Jersey, spread across 500 acres with two 18-hole championship courses. Trump National Golf Club in Sterling, Virginia, featuring a waterfront clubhouse and PGA tournament facilities. Even international properties in Scotland could face enforcement action under reciprocal judgment treaties. This represents the largest civil judgment enforcement action in American political history. Not largest criminal asset forfeiture, not largest bankruptcy liquidation, largest enforcement of a civil court judgment, where constitutional due process concluded and payment was simply never made. Legal precedent research shows enforcement actions of this scale are extraordinarily rare. Corporate asset seizures typically involve bankruptcy proceedings, where companies cannot pay their debts. White-collar criminal cases result in asset forfeiture, but that requires criminal conviction beyond reasonable doubt. This is civil enforcement, where the standard of proof is preponderance of evidence, and the judgment was never satisfied through payment or successful appeal. Professor Elizabeth Warren of Harvard Law School told The Washington Post, "This represents the largest enforcement action involving political property in American legal history. The scale reflects both the size of the underlying fraud findings and the length of time the judgment remained unpaid with accumulating interest." Federal enforcement expert David Chen of the Justice Department explained to NBC News, "When civil judgments reach this magnitude and remain unsatisfied, federal marshals have authority to seize any assets necessary to satisfy the court order. Political considerations play no role in enforcement decisions." Legal historian Dr. Sarah Mitchell from Yale told CNN, "No constitutional immunity exists for civil judgment collection, regardless of political office or social status. This enforcement follows standard legal procedures that apply to every American citizen. Pattern recognition shows that no one remains above the law when civil judgments reach final enforcement stage. The same legal system that protects ordinary citizens' rights to collect damages applies to the most high-profile cases in America." And here's the strategic irony that makes this enforcement action particularly devastating. The Trump Organization built its empire on a strategy of systematic property valuation inflation. The same properties that generated hundreds of millions in loans based on inflated values are now subject to court-ordered realistic market assessments for seizure purposes. Same properties, same legal documentation, same financial records. But now federal marshals determine liquidation value based on actual market conditions rather than loan application optimism. The overvaluation strategy that enabled decades of leveraged real estate deals becomes the enforcement vulnerability that enables rapid asset seizure. Translation: the legal system doesn't recognize political status in civil enforcement. Math eventually wins over messaging. Strategic irony number 2. Property valuations that were inflated for borrowing purposes and minimized for tax purposes now face neutral federal assessment for judgment collection. No political preferences. No negotiated valuations. Pure market-based appraisal standards applied by court-appointed evaluators. The enforcement vulnerability was created by the overvaluation legal strategy itself. When you claim properties are worth 4,000% more than tax assessments for loan purposes, those same inflated values become available for civil judgment collection when enforcement begins. Final irony beat. The law of unintended consequences operates regardless of intentions or political considerations. Decades of systematic valuation strategies designed to maximize borrowing capacity created the exact legal mechanisms that enable rapid asset seizure when civil judgments become collectible. But here's what they're not telling you about who gets hurt when federal enforcement actions shut down entire economic ecosystems. The human cost extends far beyond legal parties and political headlines. Real people with real families built their livelihoods around this property for decades. The human cost that nobody calculated when this enforcement action began. 300 direct employees, 500 indirect jobs through vendors and contractors, $50 million in annual local economic impact from a single property closure. This story has a human cost that goes far beyond politics and legal procedures. Let me tell you about Maria Santos. She's been the head catering manager at Mar-a-Lago for 25 years. Her grandmother worked in the kitchen when Marjorie Merriweather Post still lived there. Her mother managed housekeeping operations through 3 decades of private events and state dinners. Maria's daughter just started her sophomore year at Florida Atlantic University. Her son works in the property maintenance department. 3 generations of the Santos family built their entire lives around this 17-acre property. Maria told reporters outside the employee parking lot this morning, "This place was my entire life. I raised my children here. I planned weddings for senators and birthday parties for billionaires. Now I don't know how to explain to my daughter that her college tuition payment is due next week and I don't have a job." 150 immediate job losses from club closure during the enforcement period. Not temporary layoffs, not furloughs with benefits continuation. Immediate termination effective when federal marshals took operational control at 6 a.m. Healthcare benefits cut off at midnight tonight. Pension contributions suspended indefinitely. Seasonal employees who planned their entire year around Mar-a-Lago's winter season now face 6 months with no income until other luxury properties begin spring hiring. Let that sink in, and Maria Santos is not alone. James Mitchell owns 3 luxury vacation rental properties in West Palm Beach. His investment portfolio depends entirely on Mar-a-Lago area property values for rental rates and refinancing calculations. He bought all 3 properties between 2019 and 2021, using comparable sales data that included Mar-a-Lago's inflated valuations. Mitchell's rental properties. A 4-bedroom oceanfront condo purchased for $2.8 million based on area comps. A historic downtown mansion converted to luxury suites. Financed at $3.2 million. A beachfront estate bought for $4.1 million with plans for wedding venue conversion. He told the Palm Beach Post yesterday, "I bought properties using comps that included Mar-a-Lago at $700 million valuations. Those comps just evaporated overnight. My properties are now underwater by $2.3 million total, and my refinancing applications were rejected this morning." Caught between inflated purchase prices and realistic enforcement valuations, Mitchell represents hundreds of local investors whose wealth calculations depended on Mar-a-Lago maintaining its claimed market value. When federal marshals apply actual market-based appraisals for seizure purposes, comparable property values throughout Palm Beach face similar corrections. Broader economic impact spreads through luxury real estate markets when anchor properties undergo forced valuation reality checks. Lending institutions review loan portfolios. Insurance companies reassess coverage calculations. Property tax assessors face questions about systematic undervaluation for revenue collection purposes. Local real estate confidence shaken when signature properties transition from private luxury clubs to federal asset management. Buyer confidence drops. Seller expectations adjust downward. Market liquidity decreases when comparable sales data becomes unreliable overnight. The small business vendor ecosystem built around Mar-a-Lago operations faces immediate financial crisis from contract terminations. Palm Beach Luxury Catering lost a $400,000 annual contract at 8 a.m. when federal marshals suspended all club food service operations. Owner Roberto Fernandez employs 23 full-time staff and contracts with 40 seasonal workers during peak winter months. His company provided exclusive catering for Mar-a-Lago's private dining rooms, member events, and political fundraising dinners for 8 years. Fernandez told WPTV News, "We invested $200,000 in specialized equipment and staff training specifically for Mar-a-Lago service standards. 8 years building this relationship. This morning, a federal agent handed me a contract termination notice and told me to remove our equipment by 5 p.m. Elite Security Services provided 24-hour protection for Mar-a-Lago property and guests. Annual contract worth $180,000, employing 12 full-time security professionals with specialized training in executive protection and event security." Company President David Rodriguez said Mar-a-Lago represented 60% of our annual revenue. "We hired former Secret Service agents specifically for this contract. Federal Marshals informed us this morning that our services are no longer required and all access credentials are revoked immediately." Landscaping and maintenance contracts span multiple family businesses throughout Palm Beach County. Oceanfront Landscaping maintained the golf course and formal gardens, employing 15 full-time groundskeepers year-round. Luxury Property Maintenance handled pool service, building maintenance, and facility repairs for the entire estate. Domino effect calculation shows over 500 indirect jobs at risk within 30 days from this single property enforcement action. Catering staff, security guards, landscapers, maintenance workers, delivery drivers, event planners, florists, musicians, photographers, and transportation services. Economic multiplier analysis indicates $50 million in annual local economic impact from Mar-a-Lago operations,